19 states and D.C. file lawsuit against HHS over proposed ban on transgender youth care. A group of 19 U.S. states and the District of Columbia have taken legal action against the Department of Health and Human Services, its Secretary Robert F. Kennedy Jr. and the agency's Inspector General, contending that a recent HHS declaration threatens to restrict gender-affirming medical treatment for minors. The declaration, released last Thursday, declared puberty blockers, hormone therapy, and gender transition surgeries unsafe and ineffective for children and adolescents experiencing gender dysphoria, and warned that doctors who continue to provide these services could be barred from federal health programs such as Medicare and Medicaid. Although HHS simultaneously unveiled proposed rule changes that would further limit funding for such care, the lawsuit focuses solely on the declaration because the rule proposals have not yet been finalized. Filed in the U.S. District Court in Eugene, Oregon, the complaint argues that the declaration is both factually incorrect and illegal, seeking an injunction to stop its enforcement. Plaintiffs assert that the declaration attempts to pressure health care providers into ceasing care and sidesteps the mandatory notice and comment process required for substantive policy shifts. New York Attorney General Letitia James, leading the suit, emphasized that a single cabinet secretary cannot rewrite medical standards and warned that patients should not lose access to necessary treatment due to federal overreach. HHS based its stance on an internally produced, peer-reviewed report that favored behavioral therapy over comprehensive gender-affirming care and questioned standards set by the World Professional Association for Transgender Health. Major medical bodies, including the American Medical Association, have denounced the report as inaccurate and continue to oppose any limits on transgender health services for youth. The declaration is part of a broader Trump-era strategy to curtail transgender health care, which also includes two proposed federal rules that would cut Medicaid and Medicare funding for hospitals offering gender-affirming treatments to minors. Those proposals must still undergo a lengthy rulemaking and public comment period. Since President Trump's inauguration, several prominent health systems have scaled back gender-affirming services, even in states where the care remains legally protected. Currently, Medicaid funds gender-affirming treatment in just under half of the states, while at least 27 states have enacted legislation restricting or banning it. The Supreme Court's recent 6-3 ruling upholding Tennessee's ban suggests that many state restrictions will stay in place. Joining New York in the lawsuit are attorneys general from California, Colorado, Connecticut, Delaware, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, New Jersey, New Mexico, Oregon, Rhode Island,